So the Easter attacks were devastating, tragic, shocking, and I think that as we are all reckoning with the aftermath of the attacks, it's important to look at structural factors that prevented the state from responding in the way it ought to have to intelligence that was available to it. I think the first is that the National Security Council didn't function as it should have in this case. And as we think about why that might be, one set of factors relates to the lack of a proper legal foundation and developed rules of procedure for the Security Council. And so creating a law that formalizes the council in practice, dictating its composition, its powers, when it meets, its mandate is fundamental. And I would think that in particular, its mandate should include the following. So it should include briefing by security and intelligence professionals in particular of the civilian leadership of threats on the horizon. And briefing not just to one individual, but to a number of individuals. And I think that's important because if information is diffused to some extent, it broadens political responsibility. Another related reform, I think, that Sri Lanka should give careful thought to is the creation of a national security advisor, perhaps on the Indian model, which would be a senior security sector official with expertise, with a reputation for nonpartisanship, who perhaps is appointed by a 2/3 vote of the parliament, who reports to the cabinet as a whole, not just to the president. There's three different elements that Sri Lanka should look closely at. The first is having some type of a judicial or quasi-judicial process for approving surveillance, and whether through warrant or some type of other legal authorization. And so in Canada, the Federal Court of Canada has that responsibility. In the UK, it's the Investigatory Powers Tribunal that has that responsibility. But these are judicial bodies that or quasi-judicial bodies that are tasked with enforcing the legal framework governing surveillance. And that, of course, requires that there be such a legal framework, so a national intelligence statute that would establish a legal footing for intelligence, would provide for surveillance powers, and also sets conditions upon surveillance and establishes a role for such a quasi-judicial or judicial role would be essential. Another piece of the oversight framework could be some type of an agency. And so in Canada, there was recently established this year a new oversight agency for national security and intelligence. And it has a comprehensive mandate to review surveillance and intelligence activities generally from every intelligence agency in Canada in a comprehensive manner. And then the third piece is to have some type of a parliamentary committee, and that has perhaps a greater degree of independence from the Speaker and the rules of the House than parliamentary committees ordinarily might. So in Canada, there's a committee of parliamentarians now for national intelligence and security that has a statutory footing, which is unusual. It also, of the 10 members, only five can be from the governing party. And it's entitled to receive closed information as well. It can coordinate with the agency, but its remit is more strategic and policy making rather than looking at operational details. I think there's a good argument for having an opposition member chair that committee in a manner parallel to a public accounts committee that one sees in a lot of Westminster democracies. So those are a number of reforms I think Sri Lanka should have a careful look at. There might be others. One of the features of Sri Lankan politics is the highly divisive character of partisan competition between the major parties. And although they have disagreed with each other for the last 2 decades on the national question, ideologically, there's not much to differentiate the two. And so a lot of the competition is about identity and about power and elites. And so the question is, how does one design a set of institutions for security sector oversight in that highly polarized context? And so one idea I would offer up is that I think it's important that that a parliamentary committee that would have a mandated number of opposition members and perhaps even an opposition chair should be required by law to receive confidential briefings from the security sector agencies when threats go beyond a certain threshold or relate to certain issues. So a threat of an immediate threat of terror, or threats to the democratic process. And the goal there is to build in a shared sense of political risk around the need to respond to this intelligence. So if the intelligence is known to a small security-cleared group of political leaders, then they all own the problem. And they have to, they're incentivized to all respond to it. And that's true not just of the government, but also for the opposition. And so I think that's one way to kind of create a kind of a culture of commitment to the regime within which these parties compete, is to conscript them all into this process of oversight. And I think in the context of the Easter bombings, I think that had there been a properly constituted National Security Council with the Prime Minister required to attend, and if he couldn't attend, then information required to be given to him, and had there been some type of a system of parliamentary oversight where a threat of this nature required an emergency meeting of the relevant committee to be fully briefed by the intelligence services, I think history might have unfolded differently. There's no guarantee. Institutions, all they can do is increase the probability of good outcomes and reduce the risk of bad outcomes. But I think in this case they could have made a difference. And so I'm a lawyer, and I am asked a lot. You advise constitutional democracies. This country has a lot of trouble. Is a constitution going to solve them? And my response is, on its own, a constitution can't solve anything. But without a good constitution, nothing will be solved. And so, and that's true of law generally. So law is necessary but not sufficient. And so I think the inability of a law to achieve its objective should not lead us to diminish the importance of good laws, well-designed laws that operate well. But they, in addition, need to exist in a supportive political culture. And that's, of course, far more challenging. And in the Sri Lankan context, I think one has to be an internal optimist and to identify those institutions and networks within Sri Lanka that have and do function. So, for example, even in the last few years, 2015 happened, the 19th Amendment happened, the October coup was turned back by the courts, and so Sri Lanka demonstrated resilience. It voted out a would-be autocrat, and then adopted amendments to reduce the risk of a slide into autocracy, and then when there was an attempt to subvert those the Constitution from within, the courts pushed back in the spirit of those amendments and on the basis of the terms of those amendments. And so we shouldn't be disheartened. But I think that in addition to empowering those elements of the Sri Lankan state that have functioned well, we also need to engage the public, because ultimately, if people don't elect the right leaders, and if we don't have the right people in our institutions, there's nothing that good institutional design can do.